This is game over if you are following the facts in the law. He's charged with having classified information and knowing that he had classified information. He's not even charged with dissemination, that is showing it to somebody, but even that can be proved. And the tape recording is absolutely clear.
The same Mario Brothers, the same Fortnite. But there you have a veteran prosecutor saying it is game over for Trump because of what's on that tape. And then there's the trove of evidence that the prosecution has, which shows the elements of a crime. We've walked through that. And all of this raises a question I mentioned earlier tonight. How do you defend against this? Well, we are seeing some types of defenses from Trump being improvised, workshopped, freestyled in public.
Everything was declassified because I had the right to declassify.
In addition to having every right under the Presidential Records Act, is that these boxes were containing all types of personal belongings.
Golf shirts, clothing, pants, shoes. That was not a document. I didn't have a document per se.
I did everything right and they indicted me.
That was not a document. I didn't have a document per se. These were newspaper stories, magazine stories, and articles.
I'm just saying.
Fact, the defendant is not helping his case in public. Another fact, the defendant has valid legal and factual defenses. Indeed, this is one of those times, and you've seen this in news, politics, all kinds of situations where something starts to look extremely one-sided because one of the sides is really strong, Jack Smith's bulletproof detailed indictment, and the other side has so far been really weak. But the fact that Trump has put forward conflicting and weak defenses, some of the worst defenses even, doesn't mean he has no defenses. So let me say it like this. If you don't want to hear any more about what could really go on at the trial, if you don't want to understand the full facts with the entire picture, then this segment's not going to be for you. But if you do want to understand something that's gotten less attention recently that's very important, which is what are some of the valid legal, factual, and other defenses for Donald Trump in this case, to understand them, whether you agree with them or not, well, we've got the right guest, a skilled veteran defense attorney, Rob Kellner, who has direct experience with the unique situation of special counsels. Indeed, when you think about the last major special counsel, it was the Mueller probe, and one of the key officials who also had national security arguments, among others, to make was controversial Trump aide Michael Flynn, who was at one time represented by Mr. Kellner. Thank you for joining me on the program tonight.
Thank you. Great to be here.
Special counsels seem to be hard to go up against. A lot of people lose. As mentioned, you were with Flynn for a time and then not, and you've had your own independent legal voice and advocacy separately. But let's start big picture. What would be the better, potentially valid defenses for Donald Trump here, which I imagine, as a lawyer, you might think are a little different than some of what he has said?
Just a little different. It's important to keep in mind that what his defense team is going to focus on is one juror. They just need one Florida juror to vote to acquit for a mistrial. And if there is a mistrial, I personally think it's extremely unlikely that he would be tried a second time by the Justice Department. So that's what they're aiming for. And they have a relatively hospitable jury pool where they've brought the case. So with that in mind, I think there are a couple of things they're going to focus on. Number one, intent, state of mind. I think they're going to highlight for the jury that when Donald Trump was president, he had absolute legal authority, constitutional authority, to share classified documents, any government documents, with anyone he wanted to, in this country, outside the country. There's really no doubt about that. He didn't have to go through any formal declassification process to do that, or at least there's a strong argument that he didn't. Now, things are different after he's president, but I think to that one juror, the argument will be, does it make sense to prosecute somebody for doing something that they had the absolute authority to do months earlier? And also, what was his state of mind, having been in a position where he could do that? You might remember he actually tweeted out a classified satellite photo, allegedly, while he was president of the United States. He could do that. Does it make sense to prosecute somebody for doing those things after they've left office? And he'll probably argue that he thought he could still do it, right? He may even argue that he had people telling him that. We've seen news reporting that he had advisors telling him that he had certain authorities over these documents. That all goes to his state of mind. So they're going to focus on that. They're going to hammer that again and again, aiming at that one juror. A lot of judges wouldn't let that evidence in.
That's where I was going to go. Let's go into that. So, Rob, very interesting, somewhat different than some of his defenses. We showed some that self-contradict or lie. How would you actually, and you faced down the Mueller probe, you have this experience, how would a lawyer put that before a jury? How would you get that argument and that type of evidence, testimonial or otherwise, in front of the jury?
I think they'll argue that it goes to the willfulness element in the main statute that he's being charged with. It goes to his state of mind, which is relevant to that. I think there probably would be lots of judges who would not find that to be relevant or would find it to be prejudicial and would exclude that evidence. But he has a judge here who might be friendly enough. And let's remember, a district court judge in the federal system has tremendous power over how this trial unfolds. She's going to make critical decisions that will have a huge influence on the jury. So I think it's not hard to foresee that Judge Cannon might allow that kind of evidence to come in. And again, they just have to persuade one juror that that's compelling.
Yeah, and you're making an important point. I told viewers, if you want to understand where we're headed, this is the type of stuff to keep in mind. You're reminding everyone that while there's a lot of evidence that Jack Smith can summon to show, hey, get 12 people to convict, the other side is not trying to get 12 people to say he's innocent or he's a great guy. The burden, of course, not on the defense. And you're reminding us what defense lawyers might do is target those one or two jurors to basically hold out. The 10 people go overwhelming, slam dunk. I mean, he had the docs, he said it, you had the tape. And one or two of them goes, I don't know, for the reasons you just reminded us and the history with his past job and what his state of mind was, which we've reminded viewers is an element. Let me show you what Robert Ray, who replaced Ken Starr as special counsel and who defended Trump in impeachment, said about some of the defenses.
That this is all covered by the Presidential Records Act. Lyndon Johnson apparently famously said, and I don't think it's an apocryphal story, young man, son, these are all my helicopters. And that's a little bit like what, presidents and former presidents view documents. I think he's going to suggest that all of these activities by the Department of Justice are political acts. He's going to have a constitutional basis to say, I'm a former president and was once the president of the United States, and I have a right to these documents.
Which of those, if any, do you think are actually valid in a courtroom?
Well, I don't think it's valid at all to say that the president continues to own the documents after office. The laws changed after LBJ. The Presidential Records Act does not give the president ongoing ownership of the documents. That's absolutely clear. So that kind of argument, I think the judge actually probably would shoot down. However, I do think this question of intent and willfulness provides a pretty broad field to present evidence in favor of Trump. That's where they're going to focus. I don't think they're going to focus on the Presidential Records Act, for example.
Right. That Records Act is a canard because it's sort of like you're indicted on this law and you're going into court saying, well, I think this law applies. And that's just not very strong, whereas the willfulness is a required element to prove. I'm running over on time. The last question, lightning round. You faced Mueller. Who would you be more afraid of if you had a client who was a criminal defendant, the Bob Mueller probe or the Jack Smith probe?
Jack Smith is an extremely talented, I've dealt with him, he's an extremely talented, efficient, hard-fighting prosecutor. He's got a lot of vigor, he's got a lot of energy. I think any criminal defendant ought to be pretty nervous about dealing with Jack Smith.